Is anyone here to present Delegate Grammer's House Bill 166? Yeah. All right. Good afternoon. Welcome to the Judicial Proceedings Committee. We have 1, 2, 3, 4, 5, 6. We have enough members here for a quorum. We're going to start off with a brief bill hearing with Delegate Grammer with House Bill 166, and then we'll move right into our voting session. So, Delegate, go ahead. Welcome.
Thank you, Mr. Chair. House Bill 166, what it does is it puts together a task force for and I'm sorry, I'm a little winded. I ran over from the House. House Bill 166 puts together a task force for studying community standing in Baltimore County. What we're doing is we're trying to get to similar language adopted in other places like Baltimore City, so we can empower community associations to more ably handle community blight issues. So as initially drafted, the bill was it actually addressed the standing language. It's been turned into a task force. So happy to take questions, ask for a favorable.
All right. Questions from the committee? Seeing none, that'll conclude the hearing for House Bill.
Thank you.
126. Thanks. Excellent. All right. Now we'll gavel into our voting session. We are on voting list number 30. All right, we're going to start off with House Bill 1071, and Jamie is counsel. Just click on when you're ready.
So House Bill 1071 prohibits a law enforcement officer from initiating a stop or search of a person, motor vehicle, or vessel based solely on specified types of cannabis related evidence. It also prohibits a law enforcement officer from conducting a search of certain areas of a motor vehicle or vessel during an investigation of a person solely for driving a motor vehicle or vessel while impaired by under the influence of cannabis. The bill specifies that the exclusionary rule and its exceptions as judicially determined applies to the bill. Additionally, the penalty for smoking cannabis in a public place is reduced for a first offense to a maximum fine of $50 rather than $250, which is current law. And for a second or subsequent offense to a maximum fine of $150 rather than $500 under current law. In general, the bill takes effect July 1st, 2023. There.
Trying to pull up the most recent iteration of the amended bill. Is it amended again in committee or is it exactly as it came over? Yeah, because, well, council said it specifies the exclusionary rule and my amendment would have primarily addressed that. So
In the bill that the House sent over.
thanks then. Not to be the poison pill here, but the if it's an uncodified language, then I would posit that it doesn't specify it. It refers to uncodified language. So anyway, in light of that, for what it's worth, I still believe we need to be clear about our intention to not have law enforcement stop people or pull them over because of merely odor of marijuana. And so I think that the way to be clear, as we heard testimony from many people about it, is to be clear by putting it codified in the statute. And so I would offer that amendment. I think you have it somewhere. That we are clear that any stops, searches, seizures are prohibited for odor alone, and that anything derived as a result of it are subject to the exclusionary rule, as we've done in other statutes, even though the state's attorney said we haven't. So
We do.
Right, the amendment number is, the amendment number is 553827/1.
All right, so we're on the amendment, but go ahead, Senator Muse, go ahead.
The only amendment, I agree. I listened to the testimony. I listened to those who came down saying, and I think it's right. If something is you're going to say something is in law, you codify, you put it in the bill, because if you just assume it's there, they can assume it's not there. So I agree that we want to make something like that, especially with the changes that we're making. Mr. Chairman, I think that it's incumbent upon us to make it as plain as we can, because we know of some of the abuses that have occurred down through the years.
amendment, which is on the page 3 of 3 of amendment number 1 of 553827. It's right here. It says evidence discovered or obtained in violation of this section, including evidence discovered or obtained with consent, is not admissible in a trial, hearing, or any other proceeding. It's primarily the exact same language that is in the Virginia statute, which I thought was one of the strongest statutes that has been created ever since marijuana has been legalized in various states.
Is that it? That's the whole amendment?
Well, I don't
That's
know.
not the entire amendment, but that is what I chose to offer out of the initially I had an amendment that was dealing with all aspects of the bill. I'm now not offering that. I'm only offering this specific one.
Okay, so this one we have in front of us, which is 553827, most of that is not being offered, all you're
I'm
offering?
only offering the one paragraph that I mentioned.
There's been a motion.
I moved it.
You moved it. It's been seconded. I want to make sure everyone has a chance. Senator McKay was there and then it was Senator Folden. Senator Kelly, did you have your? You did. All right, sorry. Good.
So, can you, I don't have my laptop, I apologize. Can you tell me who was unfavorable on this? And does this amendment to fix, does that address anybody?
So I'm sure certainly. It will. I'm sure state's attorneys will like prefer this less,
Okay,
if that makes sense.
it does.
Okay.
Thank you, Mr. Chairman. I'm sorry, I'm trying to pull up another doc, but I'm not seeing it right now. So, here we go. So I just want to be clear. So the way this is crafted, if I'm understanding correctly, would be that I think we can all agree that there is a definite, you can tell the smell. It's definitely identifiable, the smell of burnt marijuana. So my concern is that we have, it's no different than alcohol, quite honestly, is if I'm standing on the corner as a police officer and a car pulls up, they have their window down, it's a single occupant, and either of those smells is emitted from within that vehicle. I feel that that's, even though they are both legal, it's still illegal to operate a motor vehicle while consuming either one. So I think that there should be no limitation on the fruits beyond the stop, because the stop would be justified and the stop would be legal. I think this is a terrible precedent to try to go and take away this, because, you know, when you look at what's happening, and even like in Montgomery County, I believe their testimony was, if I'm not mistaken, was that almost
Just it's
70%,
Can we?
70% of their stops from smell.
No, 100%.
Have
That's,
guns.
yeah, I got that. I want to make sure we're just, let's stay on the amendment, because I want to give Senator Folden an opportunity to
All right.
address the larger bill, but.
Yep.
I want to make sure we're just on the amendment.
The amendment would make it to where there would be no repercussions beyond the stop. Is that correct? If there was a stop? I'm sorry.
It would.
Codifies what's already in the Fourth Amendment, which is that anytime there's an illegal stop, search, or seizure, the fruit of the poisonous tree kicks in and
Correct.
says that if anything that is found as a result of the illegality, the illegal action, the unlawful action of law enforcement, then that can't be used. And you're well aware of that, Senator Folden, because that's
Yeah.
standard criminal law.
Correct.
And now that we are legalizing marijuana, it makes sense that we would treat it like we treat other things that are not criminal, and that it would not be a reason to stop for odor. And if someone violated that, if we don't do exclusionary rule, then we don't have any deterrence for the behavior. That's the issue.
So I hear what you're saying, and that's what I thought you were moving towards. But again, I stand by it. If somebody's driving by and I smell alcohol right coming out of their window and they're a lone occupant, I don't know how that's not probable cause to stop them, because it's illegal in the state to either have an open container and or consume while driving a motor vehicle.
I know, I just want to make sure, yeah, let's stay on the amendment real quick. So, yeah. Go ahead and get Senator Carter.
Under the bill, that exclusionary rule applies. This, whether or not there's just cause to stop based on.
But that's already in law though.
Anyway.
Yeah, I got it. No. There's been a motion's been second. I want to give Senator Kelly an opportunity to speak, and then I have something to say before we take action on the bill, on the amendment.
Okay, and this is, I hope, on the amendment, but if you guys decide it's on the bill, we will discuss it after the vote on the amendment. But I don't have concerns really with the amendment, because I think it's really the crux of the intent of the bill, which I support. My question is two questions that were raised in a conversation I had today, sort of along the lines of the questions that Senator Folden was asking, which is, number one, are we clear that the statute of the bill and if we put the amendment on it, then I'm fine with this, excludes people who are 21 and who are under 21. We're not clear. And then what if this car is like a hot box, right? I mean, I'm going back to the 90s, right? But back in the day, like if there's smoke billowing out of the windows, they decided to hot box a car. Would that also be included in this? Yeah, okay.
That's the Illinois language you looked at before. And then your second one, yes, that is covered under this, but keep going. Go ahead, Senator Kelly.
And language I thought was meant to be included in the part that says, I'm sorry, I've lost my page now, but you know, that it has to be as defined under 5601 of the criminal law article. So that sort of was a loose reference to under 21, but we're not clear on that.
Yeah, I mean, I had not read it that way. I could take a second look, but my read of 5601 was that personal use amount was more in line with the quantity than it was specifically who it was possessed. But I can certainly take a second look and reevaluate that.
That's helpful to me. Thank you. We can just continue with the conversation. Thanks.
So after July 1st, understanding that contraband would be, I guess, what it would be 1.5 for personal use, but 2.5
for under 21.
For under 20, at any level.
Right.
Okay, Senator Weston, Senator Walsh-Hager.
Thank you, Mr. Chair. So I'm having trouble understanding this. Jamie, can't you confirm that the constitutional standard is the fruit of the poison tree is excluded? Isn't that what the Supreme Court has held in any number of cases?
Well, it's a little bit difficult because there have been a number of cases in both the Court of Special Appeals and Court of Appeals, now the state Supreme Court. But those obviously were decided where any amount of cannabis was contraband. And obviously there's a range of intrusions into what is thought to be, protected by the Fourth Amendment, ranging from just a stop to a full-on search. And those cases have dealt with that, but not in the context of a legalization regime. So it's really difficult to say, and certainly I couldn't say what a court's view on a search post legalization is going to be as far as whether using the odor of cannabis by itself is sufficient either for reasonable suspicion or probable cause.
Well, I wasn't referring to the Maryland cases so much as the Supreme Court cases. Ever since I was in law school back in the 70s, and we were talking about the exclusionary rule back then. And the Supreme Court, for all the intervening years, it's a lot of years, I'm not a spring chick, all the intervening years has always adhered to the exclusionary rule. If the search is illegal, whatever you find as a result of the search has to be excluded as the fruit of the poisonous tree. So if that continues to be the Supreme Court's, the law of the land, as promulgated by the U.S. Supreme Court in connection with Fourth Amendment searches, then why would we need to have any language in here one way or the other about the exclusionary rule? Because that's the law of the land. Well, who was it who thought of putting the language in here about the exclusionary rule, and why?
That's courts find ways of not excluding things if they don't want it excluded, unless there's a specific language that says that you have to exclude it. That's what courts do.
Well, I'm not a Fourth Amendment lawyer, but I'm not aware that so what, the Supreme Court has made these exclusions, or local courts say, we don't care what the Supreme Court said, we're going to exclude them.
The local courts are the trial courts, so that's what happens in the trial courts. If they can figure out a way not to exclude, they tend to law on the side of public safety.
But they don't deny that the exclusionary rule is primary.
No,
they're just finding exceptions to it.
They find a reason to keep it in.
Well, so if we include this language here, why wouldn't they find a reason to keep it in?
Because then it says it has to be excluded. This is very explicit.
Okay, let's move on to Senator Walker.
Thank you, Mr. Chair. I appreciate what the sponsor is trying to do here and agree with the general outlines of it. I'm just worried. So I'm with Senator Kelly. If we do this, we have to make sure we're doing it not to prevent someone who is underage from being held accountable for driving while under the influence, or anyone really for driving under the influence of an amount that that would put them under the influence. For children, obviously, that's any amount over 0. So so I asked the Attorney General for an opinion about field sobriety tests and whether field sobriety tests count as a search or not. And the answer is that under a case called Blasey versus State, which is 167 Maryland Appeals 483 at 488, that it is a search. And so I don't think this was the sponsor's intention, but this would accidentally prevent us from doing any DRE questioning of the suspect, which, because that is the way we do field sobriety tests for cannabis. And as Senator Ariana Kelly referenced, unlike the Illinois law, this does not specify that it doesn't apply to people who are underage, because people underage, the legal amount is 0. So if we take this amendment, and I'm generally supportive of the amendment, I see what you're trying to do as a policy. We'd have to, I imagine, take something from the Illinois law that says it doesn't apply to people under 21, and you'd have to say something to the effect of this doesn't apply to field sobriety tests or DRE inquiries, because you, even if you don't want them in the car, the search, field sobriety test is still a search, and this bans any search. And so you'd still want them to be able to conduct field sobriety. So I'm with the maker of the amendment. I just think we just need to add a little bit of clarity, as Delegate Kelly referenced.
So I don't have a problem if you felt the need to specify with more clarity about the age or about the nature of the sobriety test. However, I don't agree with you, Mr. Vice Chair, because in a field sobriety test, there has been some indicia or reason to believe that a person is under the influence. And then once there is a reasonable belief or reasonable suspicion that there's under the influence, then the field sobriety tests are done, which then lead generally to probable cause to believe or not probable cause. It's to confirm or dispel whether or not there is, they're under the influence. Nothing about a field sobriety test allows a deeper inquiry into a search of the vehicle, further search of the person. It's standardized tests that are not involving a search of the person. The only time the search of the person or a vehicle, if they're in it, comes into play is if they are in fact found to be, there's probable cause to believe it, and they're then arrested, and then there's a search incident to arrest. So there's nothing in the language of the bill or the amendment that would prevent that would prevent the further inquiry into sobriety. This is simply saying that odor alone, just like, wearing gold chains in West Baltimore alone, is not justification to stop, search, or seize, period. I would imagine that the only time this would come up, if you have somebody on the street, definitely, and there's an odor without them displaying any other issues, any type of you call it disturbing the peace or public disturbance or any other signs of public intoxication, there'd be no reason, no justification to stop them. So odor alone is not reason to go further, only if there's odor plus something else. And I think we made that very clear at the hearing and in multiple other discussions that we've had. This in no way inhibits a further inquiry into intoxication or being under the influence.
And just my read of it, if you look at on bill page 3, lines 29 on down, it seems to suggest that, if you are under the influence, again, you're not prohibited from doing a search, but what it does is it put certain measures around where you can search. So if an officer comes across someone who may be intoxicated from smoking or under the influence, to use the term in here, under the influence of cannabis, if they were to do a search, they're just saying that the search has to happen within the cabin of the car. So they're not going to be looking in trunks and things. So I think in line with what the maker of the amendment was saying, this isn't stopping a search. It's just putting certain prophylactic measures around how searches have to be conducted.
Okay, I do think the Vice Chair, you brought up an issue about just impaired driving and the ability to stop. Let's say you're going 5 miles an hour on 95, or you're zigzagging, and then you're pulled over. So and let's use cannabis and alcohol. Council, I'll speak through you and ask those questions. Is there a difference between the two if we pass this bill? Can the DRE, can you be pulled out for a field sobriety test if you're swerving or there's some other indication of poor driving or intoxicated driving or driving under the influence, and then you smell cannabis? Can you further explain, please?
Well, so the bill uses the term solely. Or did I get that right? Based solely on one or more of the following. So in that hypothetical, you've got burnt or unburnt cannabis, after, you've noticed these other things. But in that context, that wouldn't seem to be the sole reason that you are like escalating from there. I think, you've got the smell plus something else there. Like the driver's driving 5 miles an hour on an interstate highway.
So switch it. So switch the scenario. You just continue this, kind of go back and forth. But so there's an initial stop for, let's say, tail light, maybe not something that indicates you're impaired, you're driving impaired, but like a tail light or an expired tag registration.
Right.
So there's that's the stop. Then you have another phase of the interaction, which is you come up and then there's smell. This bill says what? You have to have another plus factor.
Right. You're gonna need some other something additional to the odor to point to a specific violation of the law that you're after. So odor is not going to get you there by itself.
So,
You do.
yeah, you still get it. Yeah.
Correct.
And then this bill goes on to exclude it. So the odor of burnt or unburnt cannabis can't be the sole reason either.
Right. So it couldn't be odor of burnt or unburnt cannabis. That couldn't be the sole reason. Also, the possession or suspicion of possession. Do you just want me to run down the list? Possession or suspicion of possession of cannabis that does not exceed the personal use amount. So that 1.5 ounces couldn't be the sole reason for the following or for the search. And the presence of cash or currency in proximity to the cannabis without other indicia of an intent to distribute couldn't be the sole reason. Now, as I was saying that, I sort of was looking at the language and wondering, well, but what if like all three of those were present? And I don't think that gets you there either, because the lead-in language says on one or more of the following. So I don't know if that helps sort of clear that up, because if you had all three, that's just or more of the following.
Yeah, she's.
I am gotten myself, oh,
No, go ahead. It's her.
I'm just trying to figure out if we pass this law, are we treating cannabis differently than alcohol?
There is no. Yeah, but we do have rules in the transportation article for things like impaired driving that applies to both drugs and alcohol. But as far as setting a limit statutorily on what would need to be excluded, it would be different than alcohol.
Right.
Yeah.
So what is the basis? I mean, our laws around alcohol are for public safety, right? And I assume we would want public safety in, across the board. So how can we justify treating these two substances, which will now be legal, one more legal than the other perhaps, but in the eyes of the federal government, but in terms of impairment, how do we justify treating them differently? And in terms of protecting the public, being safe?
That's a sponsor question, not a Kim.
And I know, I guess, but
Not on the bill. Here's why. First of all, there are protocols in how to conduct an inquiry into alcohol intoxication. And if certain things are violated, then any evidence of a intoxication or being under influence, like the breath test or whatever, can be excluded. If there's a violation of the field sobriety test, if there's a violation of the amount of time used, if there's a violation of time between when the person is stopped and when the actual breath test is taken, there's a myriad of different things along the way of a field sobriety test. Those are standardized field sobriety tests for being under the influence. It's usually alcohol, but it's not specifically alcohol. It certainly could apply to other substances. So my point is, yes, if there are violations of the inquiry under the protocols in place for field sobriety test for alcohol, yes, the evidence can be excluded. And yes, it is in our statutory language. Yes, it is. Now, in other statutes that have been brought up over this course of this conversation, we have put the language in statute. And specifically, there have been cases that our Court of Appeals has ruled in, and they've said that the legislature should be clear about its intent. And so if they wanted exclusion, they would put it in the statute. So the issue here is either we want to be clear that we want to stop having people pulled over and searched based on the odor of alcohol now that it's ostensibly legal, or we don't. If we want to leave it like subject to discretion and individual interpretation, then I think we don't put it in the statute. But if we want to be clear, then we just simply put it in the statute. If we don't, I mean, that's the issue. Like either we want to be clear or we don't.
Okay, my question was about treating alcohol and cannabis differently. And my understanding is the law with alcohol would be that a law enforcement officer could stop you if you were reeked of liquor, right? Because there might be a concern of impaired driving. But under what we're going to do, that is not going to apply to cannabis, even though both of them can impair your driving. Is that right?
Right. So there's no sort of along the same line of questioning. There's no like the smell of alcohol. There's nothing in state law, in statutory law that says that an officer can't initiate a stop or a search of a person based on the smell of alcohol. So we don't do that. We would be doing this for cannabis, but it would not be the same for alcohol. That's
Would
true.
anybody be comfortable if we decided to do that with liquor?
No.
Just, all right, that's all I have for you.
So, thank you, Mr. Chairman. I just want to make sure we're clear on this. So, kind of piggybacking off of what my good friend from Harford County here said, and then with council's response, if you look at this, remember, we can't, this is a matter of public safety. We can't be treating things separately, first of all. They're both impairing substances. If I am in a police car, marked, unmarked, whatever it is, and I pull up next to somebody at a light, and I see them, I don't even have to smell it at this point. I just see them tip back an alcoholic beverage container. Do I have probable cause? Do I have reasonable articulable suspicion to make that stop?
So
As the law is written.
Can I just ask a question about the hypo? So,
Okay,
okay.
I thought I made it pretty clear, but okay.
So it's illegal to consume alcohol as the driver in a motor vehicle.
Bingo.
So I assume under that hypothetical, that what you are looking at is an alcoholic beverage container. It's a beer bottle, not like a.
But it's legal
so-
anywhere else for people 21 and older. Correct?
What to consume
Drink
alcohol?
beer.
Yeah, but not while inside of a motor vehicle.
Thank you. So that leads me to my next point, which is if I pull up, same scenario, and I pull up, see a gentleman, female, whoever, smoking by themselves in a car, and the odor of marijuana is just wafting right into my cruiser windows or behind you, wherever it is. Are you telling me that knowing that it is prohibited to drive impaired, that I don't have probable cause for a stop?
I think just sort of pairing the two hypos along with each other. What'll be illegal as of July 1st will be smoking in a motor vehicle or the passenger area of a motor vehicle also becomes illegal effective July 1st. So cannabis, that is.
Correct.
That would be a plus though, right? Because you would have both the odor and the observation of consuming.
So you
while
just
in
made my point. I was taking it forward
Sure.
and walking back. So you're telling me that the odor of an alcoholic beverage, I'm sorry, let me step back. The odor of cannabis, smoking inside of them in the passenger compartment of a motor vehicle is legal or illegal after July? Illegal. Does that provide reasonable articulable suspicion, not even probable cause for arrest, but RAS for a stop? Does that
reasonable articulable
create
suspicion.
enough RAS, not even PC for an arrest? No, the smell of it coming outside the cabin of a car, burnt marijuana.
So under current Maryland case law, DD is the name of the case. It was that the Court of Appeals said that or maybe that was Special Appeals. Anyways, the answer is that odor is sufficient for reasonable suspicion for a stop. And
Stop.
obviously with that,
An
you
investigative
investigate
detention.
further.
It's an investigative detention. That's what I'm telling you. This is not probable cause for arrest. This is an investigative detention. By having RAS, it provides the officer a component to be able to stop the car, ensure the safe motor vehicle operation. And then if there's other illicit elements that are a part of that stop, they should not be considered fruits of a poisonous tree, because as long as there was a reasonable RAS, reasonable articulable suspicion that things were done contrary to law, anything beyond that is absolutely covered under that Fourth Amendment. And we're trying to exclude all that. I mean, I don't understand what we're doing here. We're trying to create a new carve out for something that is going to create more car crashes, more impaired driving, and more victims of those crashes. So reasonable articulable suspicion, RAS, is not to the threshold of probable cause needed to take away someone's freedom for arrest. RAS is simply the amount needed for an investigative stop. Correct, counsel? Okay, that's all I need. Thank you.
All right, well, let me continue this then. So if there is a reasonable articulatable suspicion and there is a investigative stop, that means you can get the person out of the car and you can do this kind of thing, have them put their head back and touch their nose and do the various things that the police do to try to figure out whether the person is so under the influence of marijuana that the person shouldn't be driving, correct?
To order them to do the field sobriety test.
Yes.
For reasonable articulable suspicion,
So you've stopped the car now.
Right.
The police saw the guy either smoking or smelled the marijuana, and that gives the police sufficient cause to stop the car.
Mhm.
And at that point, they don't just say hi, they say, sir, would you please step out of the car because I believe you may be under the influence of marijuana and therefore should not be driving. I need to give you a field sobriety test.
sure.
Correct?
Well, I mean, like you asked them to submit to the field sobriety test, and off the top of my head, and it might just be because I'm just kind of spacing on it. Do you need? I need to check for you. I need to confer with my counsel on whether you need reasonable articulable suspicion to request them to participate in the field sobriety test in
Well,
the
there
first
has-
place. Obviously,
There has to
like
be some grounds for
yeah.
asking someone to step out of their car.
right.
And it sounds like Senator Fulton has identified the grounds in this case.
Say you pull someone over or.
Same idea. You,
Let's say you pull someone out of bag.
right,
and you stop.
right.
That is-
Or you smelled alcohol
Yes.
as they roll the window down.
Yes.
Then that should be enough to say, sir, I need you to step out and take a breathalyzer test. Isn't that right?
You
Um,
didn't mean breathalyzer.
Field sobriety test.
Field sobriety.
okay.
Something to hold your breath.
I'm gonna need to, I apologize. I'm gonna need to double check on the basis, just to do the field sobriety. But tentatively, I think you would need, reasonable suspicion, like in both cases. Yeah.
Well, if, let's assume that's the case for argument's sake here. And then we have the Supreme Court's Carroll decision, which held that cars are different from other places. And then when you stop someone in a car, you are permitted under the Carroll decision to search those parts of the car that are within reaching distance of the person in the car to make sure that that person can't grab a gun and correctly under this is now it's been 50 years since I've read the Carroll decision, but I remembered in law school and I don't think it's been overruled, but I'll let Mr. Fulton take over.
Is still valid, and the idea behind that is that you can do a warrantless search of a motor vehicle if there's probable cause that the vehicle contains evidence of a crime. And you can do that without a warrant because of the reduced expectation of privacy in the motor vehicle, and also the mobility of the vehicle. It's something that can be moved away, so it would be
Immediacy, it's only a
right.
grasp area.
Right.
Only reach, lunge, grasp in the immediate stop.
That's for a search incident to arrest. Under Carroll with the motor vehicle exception, I think you can go further than that.
Yeah, but you're talking under the Carroll, but you're saying search incident to arrest for the, are you
For
talking about?
search incident to arrest is reach, lunge, grasp. But
Correct.
if you under Carroll, I'm pretty sure you could do a full search of the motor vehicle as long as you have probable cause that the vehicle actually contains evidence of a crime.
A crime other than drinking.
Other than,
Let's
yeah,
go back to the initial hypo.
like okay, I mean, you're talking about a criminal act? Oh, okay, yeah, I'm sorry. I don't mean to get too, I don't want to get off in the weeds here. I'm trying to stick as specifically as we can with. Yes. Yes. If you smell alcohol, it's reasonable articulable suspicion to have them exit the vehicle. It's multiple facets because then you want to be able to remove them in the event that they did spill alcohol or something's contrary. And then when you sit there, you're evaluating them. You're looking at their eyes. Are they glassy and bloodshot? You're listening for slurred speech or other signs of impairment. You're checking their balance. All these things collectively through this evaluation create probable cause for arrest. No one individual factor within those things that I just described are solely rising to the level of probable cause. It is the combination and evaluation of them separately, but collectively that rise to probable cause for arrest. All you need is RAS, reasonable articulable suspicion, to remove the subject from the car to verify that they are safe to operate a motor vehicle as a 3,800-pound projectile down the highway. I don't know how it's not.
So in Senator West, just to follow up on your earlier question about sufficient basis to initiate the field sobriety test, it would require reasonable articulable suspicion that the driver is under the influence in order to justify doing that. Right.
Based on one bill that we did before, if you stop someone and because the law says 0.08 is illegal, right? I mean, I can stop someone, 0.08 is illegal, right?
0.08 's
What is
prima
it?
facie.
Is it, what is it, 0.08? What is it? 0.08, right? It's 0.08. I mean, if I'm 0.06, you can't arrest me, right?
No, that's not
0.08 is
true.
prima facie.
So 0.8 is what's called per se, a per se violation of DUI. Yeah, DUI. But you can still actually convict somebody even if you don't have that breathalyzer number. It's just that what state law does is it says that on its face,
So
just
without
as a
blood
matter of
test,
law,
without
you're
a
basically
breathalyzer, just because of what you observe and you say this is how they were walking.
Right, you can tell that they're
I've not
impaired.
seen that happen, but maybe, you know, maybe it does. It's not, it certainly can't, it must not be the norm. Cause I've never seen anyone who's blown beyond, you know, below that, saying I was arrested for
That they
driving.
were still convicted of.
Yeah,
of-
I've not seen this. I'm not
right.
sure about that. But we were still grappling with how do you determine what the legal limit is? So with cannabis, how do you know? I mean, do you take a blood test? They said you can't take a blood test. So how I'm talking about from the side of the defendant in all fairness. The officer can say, I saw you walking like this and person may say, but I only had half a joint. I can't be, you know, intoxicated off of that. What gives them a fair response if there really is nothing to suggest you've broken the law because of this? You had this much in your blood, you had this much. What does it with cannabis?
Well, so, there's a little bit to unpack there, but basically the current impaired driving statute already prohibits somebody from operating a motor vehicle impaired or under the influence of drugs.
I understand
alcohol,
PCP and
combination.
all applies there.
Which,
with
well, it
this
would also include
being legal,
cannabis
PCP
too.
is illegal, but now that we've made it legal,
Right.
what is the difference? I know I can't have cocaine. I know I can't PCP, but now they're saying I can smoke in a park. I can smoke a joint in a park and get in my car and drive home. But I may not be.
So, well, I mean, just to be clear, like,
I guess.
even though it's legal to possess or consume cannabis, you know, post July 1st, it would still be illegal to operate a motor vehicle while you're impaired by it or under the impaired by it.
I agree, it should, but I'm just trying to determine. If I'm arrested for that and I get in court and I'm trying to defend myself and say, but as far as I'm concerned, I was not impaired and there's no evidence that I was impaired. What do you use?
Well, so currently they use, I think it would be the same that they use now as a drug recognition expert, or, you know, they could testify to probably the DRE and, you know, I'd almost defer to somebody in law enforcement, you know, for that, the procedure on that, but just testifying to whether or not the signs that they were exhibiting were consistent with somebody who.
But then you have no
cannabis.
rebuttal. You have really no really, I would not have a rebuttal. And I'll stop with this. I'm just leery of, and I understand what we're getting at, because I believe that we're going to have people driving, you know, under influence. I believe that. But when I see historically for years and years and decades, how that's been applied disproportionately to Black and brown people in our neighborhoods. It's not that they don't, it's not that mother, brothers and sisters aren't picked up. It's just they get off. We go to jail. We go to jail. I am very cautious about giving another tool to allow that to happen without having something in place to say you broke the law, not based on my subjective, you know, I saw you trip, I saw you fall. But what is the other, you know, what is something that you could say you broke it because you went beyond this, your blood test was this. I just have trouble doing that right now and probably would not.
So just to follow up on your concern, Senator. So I just want to be clear, 08 and above, or 07 actually, because there's two categories, 08 and higher, and then there's an 07. That is prima facie evidence. Simply put, so prima facie means it's the burden is they've got it. Anything lower than that, you can still arrest. You have to have all the articulation, because then the burden shifts to the prosecution to prove more so what has happened, what is wrong. So the difference of what we're having here is, when we're talking about these DREs, is there is no measurable standard right now for impairment by marijuana. There is no measurable standard. So we are passing a law, understand, we are passing a law that impairs drivers, that does not have a process in place to record or measure nanograms of impairment in the blood. That's the best they got. And they'll stay there for days. It's not a good science. It's not the greatest science. And then alcohol conversely measures the grams of alcohol per 100 milliliters of blood. It is a defined scientific response on and during the test. This marijuana is not. So, thank you.
I don't want to detour from what our job is, which is to pass this bill, but I will say, in connection with Senator Muse's concerns, that I spent the whole afternoon and evening, summer before last, over in the Montgomery County Police Training Center. And they got a lot of people there who like to get high. And so we spent time, and periodically they'd bring them into the room and the police would subject them to these tests, which is you put your head back and then you close your eyes and you touch the end of your nose. And then the police would say, you see, he didn't touch the end, he touched halfway up his nose, or his eyes look a little glassy. And my conclusion when I left that evening, frankly, was if I were a judge, there is no way that I could conclude beyond a reasonable doubt that anyone in that room was under the influence of marijuana, because the tests were so subjective, I guess. And I came away not concluding that I could have found anyone conclusively beyond a reasonable doubt under the influence as a result of those tests. And so here we are about to legalize marijuana and put people out on the highways who've been using the stuff with no way of determining whether or not they are, legally speaking, subject to being fined or incarcerated for endangering the public safety.
All right, we're gonna go to Senator Kelly and we're gonna come back to the amendment. So Senator Kelly, go ahead.
I don't even know where we are anymore. I really like this bill. I certainly like the spirit of the amendment. I have a lot of nervousness about how it impacts people under 21. And so I think what I'm about to say is not useful to our conversation. What I was going to say is bring it back to what Senator Carter said, which was maybe there was a way we could tweak it. But I feel as though the train has left the station on that. So I'm going to take a pass on that and just state that I would like to see us make some progress on this bill because I think it comes from a good place and we want to help people, and reiterate my concern expressed earlier about the illicit market and working over the next couple of years to make sure we make that safe for everyone and driving while impaired, because I'm the parent of 4 teenagers and I get real nervous because I know how much increased cannabis use there's going to be. So I think we all share those concerns.
Thing I want to say. So the first thing I want to say is just on the issue of the age, the exclusionary rule, the amendment has really nothing to do with the age. The age is what it is under the law. And it's not part of the substantive bill. It's not reiterated in the substantive bill, to my understanding. So I don't think the amendment has anything specifically to do with whether or not age is or isn't in the bill. The exclusionary rule applies to the bill, and the bill applies to who it applies to. The second thing I want to say is Senator Muse really hit it. And, you know, we're spending an awful lot of time talking about impaired driving. And I want to just make it clear that since 2014, which is almost 10 years, 9 years now, small amounts have been decriminalized. And nevertheless, that still, for the most part, isn't really at the crux of what my intention is or what we need to do as a state of Maryland as a matter of public policy. As a matter of public policy, we need to send clear guidance to law enforcement that no longer are we a state that supports the pulling over, the stopping, the seizing, the snatching out of streets and cars of Black and brown and poor people because they're easy targets and under the guise that you smell marijuana. That is what we are trying to get to. There's no way around it. In legalizing marijuana, we accomplish nothing if we don't send clear guidance that this smell of it, now that it's legal, is no longer a justification to pull people out. And I thought, you know, it was kind of cute. Senator West said, and the officer says, and would you like to get out of the car? Well, that's not the experience that people have, okay? They say, I smell alcohol, get out of the car. And then you're on the ground. And that is what happens in real life for the most part for us. And so it would be nice if there were that politeness there, but here's the bottom line, either. So, and here's my opinion also, just real quick. Even with legalization, there's still a huge amount, that still could be considered contraband. And law enforcement will use that as a reason to continue to stop people saying we didn't know what the amount is. Regarding Senator Folden's constant talk about burnt, unburnt, even our Court of Appeals in one of its cases over the last several years said that you can't tell from odor whether it's a large amount, a small amount, whether it's burnt or unburnt. Some marijuana is potent, some is not. Bottom line is people are going to be coming home from their dispensaries and whatever. And we don't want even those people. We don't want those people pulled over. We don't want we don't want me and Senator West to both go to the same dispensary to get our stuff. And I get locked up on my way home, but he's home, happy camper, smoking his marijuana, making himself feel better. That's not what we want. And if we don't want that, then let's be clear about what we want and what we don't want. And let's not play around with this. You know what? If we pass the right law, which includes this exclusionary rule, and law enforcement and prosecutors come back in the next year or two and say, this is ruining our lives. This is the evidence we have. This is not working. But my suggestion is we've had long period of time of discriminatory policing, disparate impact of uncertain people. Let's give people a break. Let's give people a break under legalization. I know that voters didn't think when they voted to legalize this that they thought it's still going to mean Black people going to jail. I know they didn't think that, but that's essentially what we're going to still allow to happen if we don't do this. So I say pass the bill, pass the exclusion. If everybody wants to come back in a couple of years and say this is destroying everything, then let that happen. Because for decades and decades and decades, Black people and Black communities have been destroyed. So let's fix that. Let's use this opportunity to fix it. It's as simple as that.
All right, I'll just put it this way. So there's been a motion, it's been seconded. I'll just say this on an amendment to codify the exclusionary rule. And what I would just say is that the bill as we received it from the House was the product of a significant amount of debate between a number of stakeholders. And if we do this, it will delay the process and jeopardize the bill, in my opinion, if we adopt it, because it'll be in a different posture and it's gonna have to go back and gain approval from the other body. And so as they struggled to get it over here, that's my only logistical concern. So I put that out here. It's strong recommend. I agree with the spirit of the amendment, but so as not to jeopardize the passage of the bill, I just ask you to consider your vote.
So we may not get anything.
I think it puts the bill in jeopardy. Well, we still have to struggle to get it out of the Senate, then it has to go to the House, get it, and and they struggled to put the bill to where it is now. This is my recommendation would be, if you're going to do this up or down, do it clean if you want the bill to pass. So, again, the bill has been forced. Do you want to do a roll call? Are we pressing the amendment or are we not?
We had a motion on a second.
Are you pressing it?
Can I read the amendment for them?
Then you're making people vote on it.
So from the reprint for 553827/1, the only part of the amendment that the committee is voting on is on page 4 of the reprint, striking line 7 and 8 and replacing that with the language evidence discovered or obtained in violation of this section, including evidence discovered or obtained with consent, is not admissible in a trial, hearing, or any other proceeding.
Are we pressing?
Do it, it's somehow going to be detrimental to the body or to the bill. But nevertheless, I offered the amendment like weeks ago in discussions about the bill when it came over. So in light of that, yeah, I'm going to ask for a roll call on the amendment.
Vice Chair Waldstraker,
Yes, on the amendment.
Senator Sidnor,
On the amendment? On pass.
Senator West,
I'm gonna pass too.
Senator Muse.
Yes on the amendment.
I'm sorry,
Yes on the amendment.
Senator Folden,
No.
Senator James,
No.
Senator Washington,
Yes.
Senator Kelly,
So long sentence, I'm gonna be a no on the amendment, and I'm gonna ask if the amendment is not adopted, that we have some clear, specific reporting. It doesn't need to be statutory, but I want to know if there were occasions where there was evidence that was discovered or obtained under this that was used in a trial, a hearing, or any other proceeding. I want to know exactly what that was so that we can correct this and codify it next year if necessary. It's not an amendment. I don't want it in the statute. I'm stating it for the public record that that is my expectation for next session.
Senator McKay,
Yes.
Senator Carter,
My answer is yes. And and should somehow this wind up being detrimental to the passage of the bill, I learned on Friday night, we can always come back to do a reconsideration. So in the spirit of wanting the bill passed and not playing games, I'm going to say yes, because I know for sure that when there's a priority of this body, we'll figure out a way to make it happen. Thank you.
Senator Sidnor,
On that note, yes.
Senator West,
I think the bill is the amendment is passed, if I've been counting correctly. That was 6. So I'll go with Senator Carter on this one. Yes.
Chairman Smith,
No on the amendment. All right, the amendment passes. Now the bill's before you as amended. Further discussion? Motions for favorable. Sorry, Senator James.
I don't know if this helps us at all, but I did find that in 2010, our top court in the 7-0 opinion said a couple of things. One, the moderate aroma of alcohol emanating from a driver is sufficient basis for police to conduct a sobriety test. 2, they say the Fourth Amendment is irrelevant because it's an entirely different analysis. And quite frankly, the odor and the right to do this sobriety test is a much lower standard and is very consistent with what Senator Folden said. So I just want to let everybody know that that seems to be the law of the land in the state of Maryland. Anyway.
All right, motion is for a favorable as amended. It's been seconded. Roll call.
Vice Chair Waldstreicher,
Yes.
Senator Sidnor,
Yes.
Senator West,
No.
Senator Muse,
Yes.
Senator Folden,
No.
Senator James,
No.
Senator Washington,
Yes.
Senator Kelly,
Yes.
Senator McKay,
No.
Senator Carter,
Yes.
Chairman Smith,
Yes,
7-4.
bill passes with amendment. One.
Was on the floor. There were additional floor amendments that were added. So you have the reprint from the House Judiciary amendments, but it's impossible to just in this posture to put them all together for you into a single reprint.
It was put on your desk right before the voting.
The House Judiciary amendments were, it would be difficult to go into great detail with them, but to summarize, they, as far as there were basically three aspects of the bill that came out of this, which were the sensitive locations, the armed trespass, and then alterations to the licensing provisions for wear carry permits. Right. SB 1, as it was sent over to the House, did include changes to the licensing statute. Most of those have been removed by the House amendments. But let me kind of start from the top, and I'll work back, because the licensing is just later down in the bill. So as far as sensitive locations, excuse me, the the House amended some of the relevant definitions as far as sensitive locations. That includes areas for children and vulnerable individuals, government or public infrastructure areas. They added definitions to cover law enforcement and police officers. So the bill as it stands now, and I can run through the definitions for you, but as it stands now, the bill prohibited somebody from wearing, carrying, or transporting a firearm into what was defined as an area for children or vulnerable individuals. With the House amendments, that would include a preschool or pre-kindergarten facility or the grounds of that facility, a private primary or secondary school or the grounds of the school, and a healthcare facility. Now they sort of changed applicability with respect to healthcare facilities. They were, but they were changed, and that's sort of the nuance of the House amendments. With, well, you have copies of what Judiciary put out, and the substance of the definitional changes is generally covered in what the reprint in front of you has in it. But there were additional changes made that are not in the reprint, and I'm just sort of trying to think of.
Just to be clear, you have access on your floor system to the House amendments that were taken on the floor. What you do not have access under the way their system works is you do not have access to a reprint that includes all those amendments. But when I look on my floor system, I see the third reader amendments that were added to the bill. So those are accessible to you.
Are we going to be given time on the floor to read these before we have to vote on the bill? Are they long or are they brief?
The floor amendments were generally brief, and by just sort of to quantify that, they were each of them, there were 4 floor amendments. 3 of them were 1-page amendments, and the last one was a 2-page amendment. And I can sort of run down what the substance of those was.
We got a hard out at 5, so
You want me to try real quick?
yeah, we gotta be up there. Here's we're gonna
That can be asked. Yeah, I mean, it's about, did they change the part in it about like retire out of state LEOs and all that too?
So,
So-
all right, let's do this brief. Let's do this again off the floor. I want to make sure we get back to the floor. We got 2 minutes to get over there. I want to make sure we're there for the Senate, and then I'll pull people off of the floor so we can continue this in a voting session. All right, that'll conclude the voting session. We'll reconvene off of the floor in a few minutes.